So tell us a little bit about yourself and your firm, Sichenzia, Friedman, and Ference.
Sure. Hi, my name is Andrea Cataneo, and yes, I'm with the law firm of Sichenzia, Friedman, Ference. We're a 15-year-old corporate and securities law firm, full service, representing public and private companies, investment bankers, brokers, virtually any individual or entity in the corporate and securities arena. And I'm here 9.5 years now, and I'm a partner with the firm.
Now, I understand that there have been recent changes made by the Securities and Exchange Commission that may make it easier for companies to raise money. Can you shed a little light for us? Was this part of the Jobs Act?
Sure. Well, this actually was part of the Jobs Act. And in August of last year, one of the proposed changes to enable companies to raise capital, for capital formation to be a little bit easier, Rule 506 was to have a relaxation on the ban against solicitation. And this was recently enacted last month. And it is quite a dramatic change. There really haven't been any changes to Rule 506 since 1962. So this is really a dramatic change. Essentially, and I'll tell you a little bit about Rule 506. Rule 506 is an exemption from registration under Regulation D of the Securities Act of 1933. And 504, 505, and 506 are 3 exemptions, meaning a company can raise money from investors and not have to register the shares that they've sold with the Securities and Exchange Commission. So those disclosure documents have to have sufficient information so an investor is well informed, since they're not going to be able to look to the SEC for that information. 506, as long as it's been, in existence, or as long as it's been utilized by companies, has had some very specific limitations. You could raise capital from accredited investors, as many as you wanted, and really as much money as you wanted as a company, and up to 35 non-accredited investors. But the disclosure materials and the private placement offering documents had to be very thorough. You needed an audited balance sheet and a variety of other pieces of information so that an investor knew what they were getting into. Lots of risk factors and so on. As of last month, you can solicit or advertise if a company could advertise if they were raising capital. This was not really permissible back up until fairly recently. Only a licensed broker-dealer could, ask their base of investors if they had an interest in looking at a company investment opportunity. But you certainly couldn't advertise in a newspaper or have information on your website that you were looking for capital. That just was not permissible. So yeah, things have really changed in that regard, and we're seeing a lot of different reaction. I will say that from the proposal moment in August to its enactment, it was rather controversial. There were a lot of comments that were sent in by law firms, by agencies, about whether or not this was a good idea, whether it was going to be handled well by companies. But that really remains to be seen, how things are going to turn out.
So what you're saying is the company or the issuer is going to be held responsible for determining whether an investor is accredited. How do you recommend they accomplish that?
Well, I will say that the onus is now on the company. If they're going to rely on 506C, which is, by the way, the new section under which a company can raise capital and solicit investors and advertise, or can basically make it public that they're raising money privately, they have to take reasonable steps. That's really the guideline. Take reasonable steps to determine whether or not an investor is accredited. An accredited investor, by today's definition, is someone who has income of at least $200,000 a year and has a net worth of $1 million. That definition hasn't changed in over 25 years, and it probably should be, it definitely should be increased. And that's a separate discussion. There's a different category of accredited investor already in the works. But for purposes of 506, that definition is remaining as is, and it's up to the company. It's up to the issuer, the company that's raising the money, to make that determination. So how do they do it? They need to take reasonable steps, which includes income verification, perhaps, or 1099, or tax returns or perhaps a letter from their accountant. There's a variety of ways that a company might be able to determine whether or not an investor is accredited. And the SEC guidelines are really, they're looking for a facts and circumstances scenario. They're not giving a bright line, you need these 5 items. But our advice to our clients is to take extra precaution and perhaps ask for at least 3 of 5 different listed items, such as, like I've mentioned, tax returns, income verification, communication or a letter from an accountant, so that if asked later on, if someone has an issue later on, the company can confirm that they've done their homework, that they have made a genuine effort and taken reasonable steps to determine whether someone is accredited or not. If a company doesn't want to solicit or advertise, they're not going to have to go through all of these steps, and they can still sell to up to 35 non-accredited investors. However, if a company wants to rely on this new section, 506C, it's only to accredited investors, and they've got to take those steps to determine whether or not someone falls into that category.
Has a relaxation on solicitation like this ever been attempted before? And if so, were there any problems?
Yeah. As a matter of fact, back in 1992, there was a relaxation on the ban against solicitation. It was a different exemption. It was Rule 504 of Regulation D, and that's an exemption where a company could raise up to $1 million, and the shares that were sold were free trading. So if a company traded, let's say, on the pink sheets, the shares would be immediately eligible for sale thereafter. The ability for a company to advertise or solicit just kind of polluted the process, unfortunately. There were some real problems. And essentially it resulted in a wave of pump and dump schemes and other microcap frauds that ultimately led to, it damaged the market integrity to an extent, and it ultimately led to a reinstatement on the ban in 1999. After 1999, I remember this pretty well, if a company wanted to rely on 504, they had to pretty much jump over many more hurdles. There were state regulatory agencies that had to be informed prior to any investor who lived in any of those states could invest money in the company. So the blue sky compliance became much more strict. And I think a lot of this experience by the Commission, by the Securities and Exchange Commission, led to it being cautious this go round in relaxing the ban. You know, with this scenario, it's a little bit different. We're dealing only with accredited investors, but nonetheless, there are a lot of skeptics because of that bad experience with 504.
What effect do you think this will have in the long and short term for companies that are seeking capital?
Well, we're getting a lot of positive reaction and a lot of questions. Our clients are excited. Our private and public companies are excited because they believe they have a much wider range of potential investors that they can attract. And I think in the short term, there are probably going to be a lot of mistakes made. So it's important that companies rely on counsel and take a conservative approach in how they start letting the public know that they're raising capital. For example, setting up their website in such a way that they're collecting information, sufficient information, to make that reasonable determination as to whether someone is accredited or not. And it's worth going in this more deliberately. It's important, I think, to have all of their offering materials complete, filing a Form D, which is a requirement for a Reg D exemption offering. Perhaps that ought to be done in advance. The way it's been done historically is, in a 506 offering, you've got 15 days after a company takes in that first check to file a Form D with the SEC and then with any states for blue sky compliance. Now probably we'd advise a client to file that Form D in advance, almost over-disclose. Let the regulators know that this is what we're doing, and then when it's on the website, there's already a little bit of information that's out there. And collecting the information, as I've said, has to be deliberate. And it's really worthwhile to get some guidance. That's really important, I think, at this stage, while everyone is kind of getting comfortable with this new relaxation on the ban.